They thought they had her trapped in legal technicalities, interrupting her arguments with growing impatience. Her voice never wavered as she cited the precedent. Suddenly the judge fell silent as the courtroom watched in awe. A federal judge thought he could intimidate Pam Bondi in his courtroom, but what happened next left attorneys gasping. Her response not only silenced him, it changed how legal experts viewed judicial overreach. No one saw it coming, but everyone remembers what followed. The morning had started like any other in Washington, D.C. Reporters clustered outside the federal courthouse, their breath visible in the crisp autumn air, microphones ready, cameras poised, waiting for something headline-worthy. It was the kind of case that rarely made front-page news. Technical legal arguments, complicated statutes, the kind of proceeding only law professors found exciting. At least that's what everyone thought, but they had no idea they were about to witness one of the most stunning legal confrontations in recent memory. Pam Bondi arrived without fanfare, her car pulling up to the side entrance, away from the press and their shouted questions. She preferred to let her arguments speak for themselves, not sound bites crafted for the evening news. She carried a single leather briefcase, the same one she'd used for 15 years. Some considered it her good luck charm, though she'd never admit to such superstition. Inside were weeks of preparation, hundreds of hours of research, arguments refined to perfect clarity, precedents tabbed and highlighted, all leading to this moment. Security nodded as she passed through metal detectors, recognizing her from previous high-profile cases. There was a quiet confidence in her stride, not arrogance but certainty. The certainty that comes from preparation, from knowing every detail of your case, every potential question, every possible counter-argument. What she couldn't prepare for was Judge William Hargrove's reputation. Whispers followed her down the marble hallway. "You Drew Hargrove? Good luck with that," a colleague murmured as they passed. Bondi just nodded. She had heard the stories. How he ruled almost exclusively for the government, how he treated certain attorneys with barely concealed contempt, how he had never been overturned on appeal because he crafted his opinions too carefully. But Bondi wasn't easily intimidated. 20 years as a prosecutor had taught her that courtrooms weren't about personalities, they were about the law, and the law was on her side. Or so she believed. As she approached courtroom 7B, she noticed something unusual. The typical handful of spectators had grown, seats filled with law students, legal observers, even attorneys from other cases. Word had somehow spread that today's hearing would be worth watching. She felt eyes following her as she made her way to the defendant's table, setting down her briefcase, arranging her papers with precise movements. A text message lit up her phone. It was from her former mentor. "Hargrove's clerk says he reviewed your brief personally. He's been preparing all weekend. Be careful." She turned her phone face down, took a deep breath, and straightened her jacket. Across the aisle, government attorneys huddled, their table crowded with staff and paperwork. They projected confidence in numbers, in resources that dwarfed her. Small team, in the weight of federal authority behind them, but something in their constant whispering, their darting glances toward her table, told a different story. They were nervous, and they should be. The bailiff's voice cut through the murmurs. "All rise! Circuit Court of the District of Columbia is now in session. The Honorable Judge William Hargrove presiding." The room fell silent as the side door opened. Judge Hargrove entered, his black robe flowing, stern-faced, silver-haired, imposing. His reputation preceded him like a physical force. 28 years on the federal bench, appointed by a president long out of office, he had outlasted administrations, survived shifting political winds by being untouchable, unassailable. Lawyers who appeared before him spoke of his brilliance and his cruelty in equal measure, his encyclopedic knowledge of precedent, his intolerance for unprepared counsel. "Be seated." His voice carried authority without needing to be raised. He settled into his chair high above the courtroom, flipping open the case file before him. his gaze sweeping across those gathered, settling finally on Bondi. Something flickered across his face, so brief most would have missed it, but Bondi caught it, recognized it. It was dismissal. Before she had spoken a single word, he had already decided. She felt a familiar calm settle over her, the same feeling she had before every major case, when the odds seemed stacked against her. That peculiar clarity that came from knowing exactly what she was facing. The judge peered down at her over reading glasses. "Counselor, I've reviewed your motion," his tone making clear what he thought of it. "I must say, I find your arguments—" He paused, searching for the right word. "Creative." Soft laughter rippled from the government's table, but Bondi didn't react, didn't show the slightest hint of concern. "Shall we proceed?" He continued, not waiting for her response, turning instead to the government's lead attorney. "Mr. Caldwell, perhaps you can explain to me why we're even entertaining this motion." Caldwell rose, smiling slightly, believing victory was already his. "Your Honor, the defense's motion lacks any legal foundation. It misinterprets statutory language and ignores clear precedent established by this very court." The judge nodded, encouraging him, their easy rapport obvious to everyone watching. "Specifically, Your Honor, the defense contends that Section 1782 applies in this instance when 5 separate rulings from this circuit have explicitly limited its application." The judge continued nodding, a professor pleased with a student's recitation. "And the Supreme Court has never contradicted those rulings. Isn't that correct, Mr. Caldwell?" "That's exactly right, Your Honor. This wasn't a hearing, it was a performance. 2 actors who had rehearsed their lines, building toward Bondi's inevitable defeat. But she remained still, watching, evaluating, waiting for her moment. For nearly 20 minutes this continued, the judge asking friendly questions, Caldwell responding with practiced answers, building a wall of legal reasoning designed to make Bondi's position seem absurd. Occasionally the judge would glance her way, gauging her reaction, perhaps hoping to see frustration, doubt, uncertainty, but her expression revealed nothing. Finally, after Caldwell concluded, the judge turned to her, his expression shifting, from collegial to cold in an instant. "Ms. Bondi, you've heard the government's position. Do you have anything to add before I rule on your motion?" The phrasing made it clear he had already decided was merely going through the motions, offering her a chance to speak only as a procedural courtesy. The courtroom fell silent. All eyes turned to her. This was the moment they had been waiting for. Would she back down, adjust her argument, try to salvage something from this hostile reception? The government attorneys watched expectantly, some with pity, others with barely concealed satisfaction. Judge Hargrove leaned forward slightly, fingers steepled before him, waiting to dismiss whatever she might say. Bondi stood slowly, gathering her notes. She met the judge's gaze directly, unwavering. "Thank you, Your Honor." Her voice calm, measured, confident. "Before I address the government's arguments, I'd like to clarify a fundamental misconception that seems to be operating here. Today." The judge's eyebrows raised slightly, not used to being told he misunderstood anything. "Proceed," he said, the single word carrying a warning, but Bondi had faced worse, had prepared too thoroughly to be intimidated now. "Your Honor," she began, "the government argues that 5 rulings limit Section 1782, but what they've failed to mention, what they hope this court has forgotten," she paused, letting the implication sink in, "is that those rulings applied to entirely different circumstances." She opened a folder, removed a single sheet of paper, and more importantly, they directly contradict this court's own reasoning in a case decided just 3 years ago. The room tensed as the implication became clear. She wasn't just challenging the government's position, she was challenging the judge himself, using his own words against him. Judge Hargrove's expression darkened. "Ms. Bondi, I am quite familiar with my own rulings." His voice carried an edge sharp enough to cut. "Perhaps you should focus on the matter at hand instead of giving the court a history lesson." Laughter again from the government's table, but Bondi didn't falter, didn't retreat. "With all due respect, Your Honor, the history is precisely the matter at hand, and what happens next may surprise everyone in this courtroom." The federal courthouse stood imposing against the morning sky, marble columns and heavy wooden doors, speaking of authority. Inside courtroom 7B, sunlight filtered through tall windows. Hushed whispers died as the bailiff called for order. The air felt thick with tension and anticipation. Journalists scribbled notes, attorneys shuffled papers, the weight of the high-profile case pressing down on everyone present. The E. Barrett Prettyman Federal Courthouse wasn't just a building, it was a statement. Its neoclassical facade, a reminder of the permanence of law. The endurance of justice, at least in theory. That morning the usual tourists snapped photos outside, unaware of the drama unfolding within. But those who worked in the law, they knew. They sensed something different about today's proceedings. Courtroom 7B was located on the third floor at the end of a long marble hallway, its double doors heavy oak worn smooth by decades of nervous hands pushing through. Inside the room soared upward, 20-foot ceilings adorned with intricate moldings. American flags stood at attention behind the bench, their fabric still and silent in the climate-controlled air. The gallery seats were mahogany, uncomfortable by design. Justice wasn't meant to be comfortable. It was meant to be respected. Every surface gleamed under the careful attention of custodial staff who arrived before dawn, polishing brass fixtures, wiping fingerprints from tables, preparing the stage for the day's legal theater. The courtroom was divided by a waist-high wooden barrier, separating observers from participants, a physical reminder of the line between watching justice and experiencing it. On one side sat the public, law students hoping to learn, journalists hunting for stories, curious attorneys stealing time from their own cases to witness Bondi face Judge Hargrove, a matchup that had sparked interest throughout the D.C. legal community. On the other side, the government's table overflowed with resources, 5 attorneys in identical dark suits, assistants passing notes, legal interns fetching documents. They had spent a small fortune preparing, taxpayer dollars funding every minute of their preparation. Directly across the aisle, Bondi's table seemed almost empty by comparison. Just her and a single associate, David facing Goliath with a briefcase instead of a sling. The court reporter sat to the right of the judge's bench, fingers poised over the stenotype machine, ready to capture every word, every objection, every subtle shift in the legal battle. Court clerks moved efficiently around the edges, organizing exhibits, updating dockets, their eyes occasionally darting toward the main players. Sensing the tension building like a thunderstorm, the judge's bench itself rose above it all. A massive desk of dark wood positioned like a throne, elevating its occupant both physically and symbolically above the fray. Unlike most modern courtrooms, 7B maintained its original layout, unchanged since the 1950s. No computers, no screens, just wood, paper, and the weight of legal tradition. The walls were lined with portraits, previous judges who had presided here, their stern faces watching the proceedings, as if offering silent judgment across time. Through the tall windows, morning light cast long rectangles across the floor, occasionally broken when clouds passed overhead, turning the room momentarily darker, as if nature itself responded to the changing mood. The American flag's eagle finial caught this light, reflecting it downward, creating a small pool of gold. On the judge's bench, a spotlight for the drama about to unfold. At precisely 9:30, the side door opened, revealing the judge's chambers beyond. The bailiff's voice commanded attention. "Presence, all rise." The room responding as one body, standing out of tradition, respect, or simply self-preservation. Because in this room, Judge William Hargrove's authority was absolute. or so everyone believed, the sound of shuffling papers. Rustling clothes, breathing, all seemed magnified in the perfect acoustics. This room, designed so that even a whispered objection could be heard clearly from every corner. Nothing missed, nothing overlooked. Justice required perfect hearing, or at least that's what the architects believed. On the back wall, a large clock ticked steadily. Its mechanical precision, a reminder that court time was different from ordinary time. Here, minutes could determine lifetimes, seconds could separate freedom from incarceration, and today, each moment carried the weight of a legal confrontation. Years in the making, outside the windows, Washington continued its business. Government workers hurried between buildings. Tourists examined maps. Power brokers conducted meetings over coffee. The machinery of the Capitol grinding forward, unaware that in courtroom 7B something remarkable was brewing. The scent of old books, lemon polish, and lightly perfumed notepaper mingled in the air. The smell of justice, some veteran clerks joked, but today there was something else, the faint electric tension of anticipation. When the crowd believes it's about to witness something rare, the ambient temperature seemed to drop slightly when Judge Hargrove entered, his presence changing the atmospheric pressure like a weather front moving through. Court officers stood at attention, their uniforms pressed, badges gleaming, ready to enforce whatever order might come to maintain the decorum that Hargrove demanded. The court reporter nodded slightly, acknowledging the judge's arrival, fingers hovering, ready to begin the official record, capturing every word for history, for potential appeals, for the legal textbooks that might one day cite this very case. At the prosecution table, lead attorney James Caldwell adjusted his tie, a nervous habit he'd never managed to break despite 20 years of courtroom experience. He had argued before Hargrove dozens of times, knew his preferences, his pet peeves, how he liked arguments structured, which precedents he favored, which he dismissed. But something about today felt different. Something in the air, in Bondi's calm demeanor, made him uneasy, made him question the victory he had assumed was guaranteed. Behind him, his team continued organizing documents, color-coded tabs marking key exhibits, sticky notes flagging important citations. A small army prepared for legal battle, or perhaps overkill, for what should be a straightforward dismissal. At her much less crowded table, Pam Bondi arranged her materials with methodical precision, a single legal pad, fountain pen, a marked-up statute, and 3 case files bound in red folders. Her preparations seemed sparse by comparison, but those who knew her recognized the signs, the economy of her movements, the careful arrangement of materials, everything positioned for maximum efficiency, nothing superfluous, nothing wasted. Her associate, a former clerk named Thomas, sat slightly behind her, reviewing notes, occasionally sliding a document forward, their choreography practiced, seamless. They had worked through the weekend, rehearsing arguments, anticipating objections, preparing for every possible scenario. They knew the odds, they knew the judge's history, but they also knew something the government didn't, something that changed everything. The sounds of the courtroom formed a subtle symphony. Leather chairs creaking as people shifted, papers rustling, pens scratching. The occasional cough quickly stifled, the soft murmur of whispered conversations that died instantly when the judge cleared his throat. It was a soundscape familiar to anyone who spent their life in the law, both comforting and intimidating, the rhythm of justice in motion. The court clerk rose, documents in hand. Docket number 22, CV 4781. United States versus Westmoreland Corporation et al. Buzz. His voice carried the practiced neutrality of someone who had announced thousands of cases, each one life-changing for those involved. But just another day's work for the court. Judge Hargrove nodded, adjusted his glasses, and opened the case file before him. His movements deliberate, unhurried, conveying absolute authority, absolute control. This was his domain, his arena where he had reigned unchallenged for decades. The silence deepened as he reviewed the documents. No one dared speak, no one dared move. It was as if the room collectively held its breath, waiting for him to acknowledge what everyone knew. This case was different. The legal question at its heart could change how international evidence was handled, could open doors previously thought closed, could shift the balance between government authority and individual rights. The stakes couldn't be higher, which is why the government had brought its full force, why Hargrove had been assigned the case, his reputation for siding with authority well known throughout the circuit. When he finally looked up, surveying the room, his gaze lingered on Bondi, slightly longer than necessary, something in his expression, a flicker of recognition perhaps, or the barest hint of curiosity before it vanished behind judicial impassivity. "Councillors," he said, his voice filling the room without effort, "I've reviewed the briefs and supporting documents." He closed the folder with a snap. "I see no reason to waste the court's time. The issues seem quite clear to me." Those who had appeared before him before recognized the tone. He had already decided the hearing was merely procedural, a formality before issuing his ruling, but Bondi remained composed, unfazed, as if she had expected nothing less, as if this too was part of her calculation. The stage was set, the players assembled, the opening moves made, but no one, not even Judge Hargrove himself, could anticipate what would happen next. In a courtroom designed to showcase power, a different kind of authority was about to emerge, the authority of preparation, of knowledge, of truth spoken without fear, regardless of the consequences. Judge William Hargrove entered with practiced authority. 30 years on the bench had given him an air of untouchable confidence, known for his cutting remarks and little patience for unprepared attorneys. His reputation for favoring government positions was whispered about, but never challenged. Across the room, Pam Bondi stood reviewing her notes, her tailored navy suit and calm demeanor betraying nothing. She had faced tough judges before, but today's case carried stakes beyond the ordinary. The rights of thousands hung on her arguments. Judge William Hargrove, the name alone commanded respect in legal circles, or fear, depending on who you asked. At 68 his hair had turned completely silver, but his mind remained razor-sharp, his memory legendary. He could recall cases from decades past, cite obscure precedents without reference, quote statutes verbatim, leaving unprepared attorneys stammering. He wore his judicial robes like armor, pressed perfectly, not a wrinkle in sight. Beneath them, a tailored suit, French cuffs monogrammed with his initials. Everything about him projected authority. From his ramrod straight posture to his penetrating gaze that seemed to look through you rather than at you. He had been appointed to the federal bench during the first Bush administration, survived 4 presidents since, his tenure marked by consistency, if not always fairness. Those who practiced before him regularly knew he expected perfection, demanded preparation, and showed no mercy to those who wasted his time. His clerks were selected from the top law schools. Harvard, Yale, Stanford, Columbia, worked 14-hour days, 7 days a week. Turnover was high, burnout common, but a year with Hargrove guaranteed a career, the pain worth the prestige. He ran his courtroom with military precision. Tardiness was unforgivable, cell phones strictly forbidden. Even the smallest procedural errors drew his wrath. In my courtroom, he often said, "The law is respected, not merely followed." But beneath the polished exterior whispers followed him through the courthouse halls. How he consistently ruled in favor of the government, how defense attorneys faced an uphill battle, how his friendship with senior Justice Department officials raised questions never spoken aloud. He had been overturned on appeal only 3 times in 30 years on the bench, not because he was always right, but because he crafted his opinions so carefully, finding obscure procedural grounds that made them difficult to challenge. To the legal community he was a paradox, brilliant but rigid, respected but feared. A judicial mind ahead of his peers, but somehow behind the evolving understanding of justice. Today he seemed particularly focused, had arrived at the courthouse before dawn, spent hours reviewing the case files, a rarity for someone who typically relied on clerk's summaries. Something about this case had captured his attention, perhaps the legal question at its heart. Perhaps the fact that the defendant had resources to match the government's, or perhaps it was Pam Bondi herself, whose reputation had begun to rival his own. Across the courtroom, Pam Bondi stood, a stark contrast to Hargrove in every way. At 45, she had already established herself as one of the most formidable attorneys in Washington. Her path, unlike most of her peers, hadn't been direct, hadn't been privileged. Raised in Tampa by a single mother who worked 2 jobs, scholarship to Florida State University, law degree from a state school, not an Ivy League, she had built her career brick by brick, case by case, reputation by reputation, first as a state prosecutor, then assistant U.S. attorney, finally Florida's attorney general before moving to private practice, where she took on cases others deemed unwinnable. Her record spoke for itself. 27 major trials, 23 victories, 4 settlements each favorable to her clients. She didn't seek the spotlight, didn't give interviews. Let her work in the courtroom speak for itself. Her appearance was understated elegant, a navy suit not from designer boutiques, but tailored to perfection, minimal jewelry, a gold watch, a small pearl necklace, simple studs, her dark hair cut in a practical bob, nothing to distract from her arguments, nothing to suggest style over substance, but it was her eyes that people remembered after facing her in court. Intense, intelligent, assessing, missing nothing, storing everything. What separated Bondi from countless other attorneys wasn't just intelligence or preparation. It was her ability to see what others missed, to find the overlooked statute, the forgotten precedent, the procedural exception that changed everything. She had once won a case by citing a footnote in a Supreme Court decision from 1937 that everyone else had overlooked. Her former law professor, now a judge himself, had said, "Of her, Pam doesn't just read case law. She absorbs it, makes it part of herself, then redefines it when necessary." Unlike many high-profile attorneys, she kept a small team, traveled light, preferred quality over quantity. Her current second chair, Thomas Wheeler, had been with her. For 7 years, their working relationship so seamless they communicated with glances, subtle gestures, a nod, a raised eyebrow, a tapped finger, conveying complex legal strategies without words. Those who had opposed her in court learned quickly not to underestimate her. Her soft-spoken manner, Midwestern politeness, often lulled opponents into a false sense of security until it was too late. Today, she wore no expression at all, a blank canvas that revealed nothing of the thoughts racing behind it. She had prepared for this hearing for months, not just the legal arguments, but Hargrove himself. She had studied every ruling he'd made in similar cases, read interviews, attended lectures, spoke with attorneys who had appeared before him, learned his habits, his preferences, his biases. She knew he would be hostile, knew he would favor the government, knew he had likely decided before she spoke a word, and still she stood confident, prepared, because she had seen something everyone else had missed, something that would change everything. Around them, the drama of their confrontation had drawn. An unusual crowd, clerks from other judges, civil attorneys stealing time from their own cases, the courthouse staff finding excuses to enter the room, all sensing that today something extraordinary might happen. The air felt charged with possibility. Thomas leaned forward slightly. "You sure about this?" he whispered, barely audible even to her. Bondi gave a nearly imperceptible nod. She was sure she was ready. Across the room, James Caldwell, lead attorney for the Department of Justice, arranged his notes with methodical precision. At 53, he had spent his entire career in government service, had argued before the Supreme Court 4 times. Won 3, a record that pleased him. He had faced Bondi twice before, lost both times, a fact that haunted him. Today he had brought reinforcements, a team of 5 attorneys, specialists in different aspects of the complex case at hand, each exhaustively prepared. He believed in overwhelming force, in drowning opposition with resources, with manpower, with procedural motions. His style was aggressive, relentless, preferred to attack early, establish dominance. He and Judge Hargrove had a long-standing relationship, not friendship exactly, but mutual respect built over decades of cases. They understood each other, operated from the same playbook, believed in the same principles, the same interpretation of justice. Caldwell glanced at Bondi's table. Just 2 people against his team of 7. He felt a flicker of something like pity mixed with satisfaction. Today would not be like their previous encounters. Today he had Hargrove on his side. Today the deck was stacked. The outcome predetermined, or so he believed. The bailiff's voice cut through the murmurs. "All rise!" The room responded as one. Judge Hargrove took his seat, adjusted his robes. "Be seated." His voice carried authority, a command, not a request. He surveyed the room, gaze finally settling on Bondi. "Counselor, I understand you filed a motion challenging the government's use of evidence obtained through Section 1782 proceedings. Is that correct?" "Yes, Your Honor," Bondi replied, her voice calm, measured, respectful. Nothing in her tone betrayed the significance of what was about to unfold. "And you're aware," Hargrove continued, reading from notes before him, "that this court has consistently held that such evidence is admissible in cases involving foreign financial transactions." "I'm aware of the court's previous rulings, Your Honor," Bondi replied. Something in her response caught Hargrove's attention. Not what she said, but how she said it, with absolute certainty, as if she knew something he didn't. He frowned slightly, studying her more carefully. 30 years on the bench had taught him to read people, to sense weakness, hesitation, doubt. He saw none of these in Pam Bondi, only a confidence that seemed at odds with the legal reality she faced. "Very well," he said finally. "Mr. Caldwell, I believe the government opposes this motion." Caldwell stood, straightening his tie. "Yes, Your Honor, we do. The defense's position contradicts established precedent, not only in this circuit, but nationwide." Hargrove nodded, encouraging him to continue, their familiar rhythm establishing itself, judge and prosecutor in perfect sync. While Bondi waited, patient, observant, gathering information with every exchange, this wasn't just a hearing. It was a contest of wills, a clash of legal minds, a battle between established power and emerging challenge. No one in that courtroom, not even Judge Hargrove himself, could predict how this confrontation would end. But everyone sensed its importance, history being written before their eyes. The interview began with standard questions: electric vehicles, space exploration. Morgan's tone shifted subtly, more pointed. The panel beside her exchanged knowing glances. They had seen this before, the slow build to a takedown. Musk answered calmly, his responses measured, his eyes watchful. Something about his composure unsettled Morgan. The hearing began with standard procedural matters: motions, arguments, counter-arguments, but the judge's questions to the prosecution were softball easy, his tone shifting noticeably when addressing Bondi, interrupting her repeatedly, questioning basic legal principles. Attorneys exchanged glances, recognizing the pattern forming. The judge wasn't just questioning her case, he was attempting to dismantle it before it began. Bondi maintained her composure, answering precisely, but the judge's patience was wearing thin. Caldwell rose to begin the government's argument, button of his suit jacket fastened just moments before, a practiced gesture, part of his courtroom. Ritual? His voice carried confidence, authority, the assurance of someone who had never lost a case, at least not in this courtroom, not before this judge. "Your Honor, the defense's motion lacks merit," he began his standard opening. "It contradicts clear precedent established in 5 separate rulings from this very circuit, including Thompson v. Richardson, Myers v. Department of Treasury, and United States v. Keller." The judge nodded, following along, making occasional notes in the margin of his papers. In each of these cases, Caldwell continued, this court has consistently held that evidence obtained through Section 1782 proceedings is admissible in cases involving foreign financial transactions when three specific conditions are met. He held up his hand, ticking off points. First, the evidence must be obtained through proper channels. Second, it must be authenticated by relevant authorities. And third, it must be directly relevant to the matter at hand. His rhythm was perfect, his delivery flawless, years of practice evident in every gesture, every carefully chosen word. In the case before us today, all three conditions have been satisfied. The defense's objections are based on technicalities, not substance, procedural complaints, not legal principle. He turned slightly, gesturing toward Bondi without looking at her, a subtle dismissal. Ms. Bondi would have this court believe that a comma placement in the statute somehow invalidates. Years of consistent interpretation, a ripple of amusement from his team, the verbal equivalent of an eye roll. It's the kind of argument that makes for interesting law review articles but has no place in actual judicial practice. Judge Hargrove allowed himself a small smile, appreciating the backhanded compliment, the dismissal clothed in professional language. "Continue, Mr. Caldwell," he said. Clearly engaged in the argument, Caldwell nodded, warming to his subject. "Your Honor, the legislative history is clear on this point." He reached for a document handed to him by an assistant. Congress intended Section 1782 to facilitate, not hinder, the gathering of evidence across borders. The defense's narrow interpretation would effectively gut the statute's purpose, rendering it useless in precisely the cases where it's most needed. Judge Hargrove nodded again. "And the Sullivan memo?" he asked, referring to a Justice Department directive that few outside the government even knew existed. Caldwell didn't miss a beat. "Addresses this exact scenario, Your Honor." Another document appeared in his hand, as if by magic. It specifically states, and I quote, "When evidence is properly obtained through Section 1782, subsequent challenges based on procedural technicalities should be viewed with appropriate skepticism, particularly when such challenges appear designed to impede legitimate investigations." The judge made another note. "And in your view, Mr. Caldwell, that's what we have here." "Precisely, Your Honor." Caldwell's voice took on an earnest quality. "The defense has constructed an elaborate argument based on selective reading of the statute, ignoring both its purpose and this court's consistent rulings." He paused for effect. "It's a desperate attempt to exclude crucial evidence that directly links the defendants to financial misconduct on a massive scale." Throughout this exchange, Bondi sat perfectly still, making occasional notes, watching, listening. Nothing in her expression revealed whether Caldwell's characterization bothered her, whether his dismissive tone registered at all. But those who knew her well might have noticed a slight tightening around her eyes, the only sign that she was fully engaged, absorbing every word, every implication, preparing her response. Judge Hargrove turned to her. "Miss Bondi, it seems the government believes your argument is not only contrary to precedent, but potentially obstructionist." His tone made clear which side he favored. "Would you care to respond before I rule?" The question was perfunctory, the outcome seemingly predetermined. Attorneys in the gallery exchanged glances, some with sympathy, others with curiosity, wondering how she would handle what appeared to be a losing battle. Bondi rose smoothly. "No wasted movement, no unnecessary gesture." "Thank you, Your Honor." Her voice carried just as much authority as Caldwell's, but without the performative quality. "Before addressing Mr. Caldwell's characterizations, I'd like to clarify several factual inaccuracies." Hargrove's eyebrows rose slightly. "Inaccuracies, Ms. Bondi?" The question carried a warning, an implication, that she was on dangerous ground. challenging not just the government's position but the court's own understanding. Yes, Your Honor, she continued undeterred. Mr. Caldwell cited Thompson versus Richardson as controlling precedent in this matter, but that case involved domestic financial transactions, not the cross-border transfers at issue here. Caldwell shifted in his seat, a flicker of concern crossing his features. Similarly, Myers versus Department of Treasury addressed evidence gathered under Section 3121. Not Section 1782, as Mr. Caldwell suggested. She didn't raise her voice, didn't change her tone, simply stated facts, corrections, with absolute precision. Hargrove frowned. Ms. Bondi, are you suggesting that government counsel has misrepresented precedent to this court? The question hung in the air, dangerous, loaded. Not at all, Your Honor, she replied without hesitation. I'm simply clarifying the record, ensuring we're all working from the same set of facts. Her diplomatic answer did little to conceal the implicit criticism. Caldwell stood immediately. Your Honor, if I may. His voice had an edge now, the easy confidence replaced by something sharper. The defense counsel is playing semantic games. The principles established in Thompson apply equally regardless of whether the transactions crossed borders. Judge Hargrove nodded. That has indeed been this court's position, Ms. Bondi. Do you have anything substantive to add, or are we merely debating legal trivia? The dismissal was clear, the message unmistakable. He was running out of patience, but Bondi remained unruffled. Your Honor, I believe what constitutes controlling precedent is hardly trivial. The room tensed at her response, direct but not disrespectful, challenging but remaining within bounds. But to address your question, yes, I have something substantive to add. She turned to her associate, who handed her a red folder. The government has repeatedly referenced this court's consistent interpretation of Section 1782, yet there's a ruling from this very court that contradicts everything Mr. Caldwell has argued today. She opened the folder, removed a single document. May I approach the bench, Your Honor? Hargrove hesitated briefly, then nodded. You may. She walked forward, document in hand, her heels clicking against the polished floor, the sound echoing in the suddenly quiet room. Caldwell watched, eyes narrowed, sensing something unexpected, something potentially dangerous. Bondi had spent months preparing for this case. Nights reviewing precedents, mornings rehearsing arguments. She understood what she was up against. This judge had history with her type of case, had ruled against similar arguments 7 times before. Colleagues had warned her, he'll never let this argument stand, suggested she find another approach, another venue, but she had seen something in the law others missed, something that would change everything if given the chance. If she could just get him to listen. 3 months earlier, long before this confrontation seemed inevitable, Pam Bondi sat alone in her office, surrounded by stacks of legal texts, case files marked with colored tabs, yellow pads filled with her precise handwriting. The clock on. The wall read 2:17 a.m., but she showed no signs of exhaustion. This wasn't unusual for her. The quiet hours after midnight, when phones stopped ringing, emails slowed, when she could think without interruption, these were her most productive hours. Had been since law school, when she worked the night shift, at a diner, studying between serving customers. The Westmoreland case had consumed her for weeks now, every spare moment devoted to finding a way forward, a path through what seemed impenetrable. The government had built a formidable case using evidence obtained through Section 1782, a provision allowing evidence gathering from foreign jurisdictions for use in foreign proceedings. But they had stretched its application, using it for domestic prosecution, contrary to its original intent. 6 different attorneys had already declined this case. Unwinnable, they said, the government's interpretation is established. Precedent is against you. Judge Hargrove will never allow the challenge. But something didn't sit right with Bondi. Something in the statute's language, in its legislative history, suggested an alternative interpretation, one that had been overlooked, buried under years of expansive readings. She picked up the worn copy of the statute, running her finger down the page, stopping at the key section, reading it again for perhaps the 100th time. The district court of the district in which a person resides may order him to give testimony or statement or to produce a document or other thing for use in a proceeding in a foreign tribunal. The words, "for use in a proceeding in a foreign tribunal," seemed to leap off the page, the clear limitation on its application. So why had courts consistently allowed this evidence in domestic cases? She reached for another text, the congressional record, from when the statute was passed, finding the highlighted section where Senator Edward Long had explicitly stated, "This bill is intended solely for foreign proceedings, not as a backdoor for domestic prosecution." The legislative intent couldn't have been clearer, but somewhere along the way, courts had begun expanding its application, allowing what was clearly prohibited. Her phone buzzed. A text message from Thomas, her associate, found something interesting in Hargrove's record, calling now. Moments later, her phone rang. "It's almost 2:30 in the morning, Thomas," she answered, unable to keep the amusement from her voice. "Do you ever sleep?" "The pot calling kettle," he replied. "I knew you'd be up." "What did you find?" she asked, reaching for a fresh legal pad. "Westlake v. United States 2020. Hargrove wrote the opinion. He explicitly ruled that 1782 evidence can't be used in domestic prosecutions without additional authentication. Bondi sat up straighter. "Are you certain?" "Reading it right now, it's crystal clear." He wrote, and I quote, "The statute's specific language regarding foreign proceedings must be interpreted narrowly when agencies attempt to use such evidence in domestic prosecutions." End quote. Bondi was already typing the case into her database. "How have I never seen this cited?" "That's the interesting part," Thomas continued, excitement in his voice. "It's barely been cited anywhere. It was a complex case, mostly about other issues. This was buried in the middle of a 47-page opinion. Most summaries don't even mention it." The document appeared on her screen. She scanned it quickly, finding the relevant section. "This contradicts everything he's ruled since." "Exactly," Thomas agreed, "including 3 cases in the last year alone." It's like he forgot his own precedent, or chose to ignore it. Bondi thought but didn't say aloud. This changes everything. If he ruled this way before, he can again. We just need to remind him of his own words. "Think that'll work?" Thomas sounded skeptical. "Hargrove doesn't strike me as the type who appreciates being corrected." "It's not about correction," Bondi replied, mind already racing ahead, planning strategy, anticipating reactions. "It's about consistency, jurisprudential, integrity. We're not challenging him. We're honoring him by taking his words seriously." There was silence on the other end, then a soft chuckle. "That's why you win cases no one else will touch. The way you frame things. Don't celebrate yet," she cautioned. "This is just the beginning." That conversation had launched 3 months of intensive preparation. Bondi and her small team working around the clock, building a case that hinged on a single precedent, a ruling the judge himself seemed to have abandoned. She had rehearsed this moment dozens of times, anticipated every possible reaction, prepared for resistance, dismissal, even anger. But she hadn't prepared for what actually happened. The subtle shift in Hargrove's expression when confronted with his own words. Not anger, not dismissal, but recognition, and something else, something unexpected, respect. Across the courtroom, Caldwell was speaking again, attempting to regain control of the narrative. "Your Honor, Westlake was decided on multiple grounds. The Section 1782 discussion was merely dicta, not essential to the holding." Judge Hargrove held up his hand, silencing him mid-sentence. "I'm well aware of what was dicta in my own opinion, Mr. Caldwell." His tone had shifted completely. Gone was the easy familiarity, replaced by something cooler, more judicial. Bondi watched carefully, recognizing the crucial moment when a case balanced on a knife's edge could fall either way. "Ms. Bondi," The judge turned to her. "You've raised an interesting point." The understatement drew soft laughter, quickly stifled. When Hargrove's gaze swept the room. "However," he continued, "even if we accept Westlake as controlling precedent, how do you reconcile it with my subsequent rulings in Johnson, Reed, and Blackwell?" He was testing her now, seeing if she had done her homework, if she had anticipated this very question. She had. "Your Honor, those cases are distinguishable on their facts," she replied without hesitation. "In Johnson, the evidence was used in parallel foreign proceedings, satisfying the statute's requirement. In Reed, the defense failed to raise the issue properly, waiving their right to challenge, and in Blackwell, the evidence was obtained through multiple channels, not just Section 1782, making its admissibility overdetermined." She paused briefly, allowing her answer to register. "None of those cases presented the clean question before us today, where evidence was obtained solely through Section 1782, explicitly for use in domestic prosecution, with no parallel foreign proceeding." The courtroom was silent, attorneys watching with undisguised interest as Judge Hargrove considered her response. Even Caldwell seemed momentarily at a loss, faced with an opponent who had clearly studied every aspect of the judge's jurisprudence. Hargrove leaned back slightly, studying Bondi with new interest. "You've done your research, counselor." It wasn't a question, but she answered anyway. "It's what you expect from attorneys in your courtroom, Your Honor. Thorough preparation, attention to detail, and respect for precedent." The implied message clear. He expected these things from others, but was he holding himself to the same standard? A lesser judge might have taken offense, might have seen it as challenging his authority, but William Hargrove hadn't become a legend by being thin-skinned. "Indeed, Miss Bondi," he replied, a hint of something like appreciation in his voice. "Well-prepared counsel make for better rulings." He glanced down at the Westlake transcript again, then back at Caldwell. "Mr. Caldwell, how does the government respond to Ms. Bondi's distinctions?" Caldwell stood, adjusting his tie, a nervous gesture he couldn't suppress. "Your Honor, the government maintains that Westlake is factually distinguishable from the present case." But his voice lacked its earlier certainty, his argument sounding hollow even to his own ears. He was improvising now, facing an argument he hadn't anticipated, a precedent his team had somehow overlooked in all their exhaustive preparation. As he spoke, Bondi remained perfectly still, not interrupting, not challenging, allowing his increasingly circular argument to reveal its own weaknesses. This was a strategy she had employed throughout her career, knowing when to press and when to step back, when to let opponents talk themselves into corners. "Counselor," the judge finally said, leaning forward, his voice carrying that particular tone that silenced rooms. "Your argument fundamentally misunderstands the statute. Perhaps a first-year law student would make this mistake, but I expect better from someone with your experience." The room tensed at the thinly veiled insult. Government attorneys smirked slightly, sensing victory. The judge continued, pressing his advantage. "Can you cite a single case that supports this novel theory?" His emphasis on novel dripping. With dismissal, the trap was set, the humiliation nearly complete. The next morning, courtroom 7B was packed, standing room only, every seat filled. Word had spread throughout the legal community about the previous day's unexpected turn, the confrontation between Bondi and Hargrove, the revelation of the overlooked precedent, the judge's uncharacteristic reconsideration. Even attorneys with no connection to the case had found reasons to be present, to witness what promised to be a defining legal moment. Judge Hargrove entered precisely at 9 a.m., his expression giving nothing away, the bags under his eyes, the only indication that he might have spent a sleepless night reviewing his own past rulings, searching for consistency where perhaps there was none to be found. "Be seated," he commanded. The room fell silent immediately, tension so thick it seemed to press against the walls. Before we continue yesterday's discussion, he began, voice carefully neutral, I want to clarify something for the record. Attorneys exchanged glances, uncertain what was coming. This court values consistency in legal reasoning, adherence to precedent and statutory text, regardless of the parties involved or the outcome desired. His gaze swept the room, lingering, briefly on Bondi, then Caldwell, neither revealing anything in their carefully composed expressions. Mr. Caldwell, you may proceed. Caldwell rose, buttoning his jacket. Overnight, his team had completely restructured their argument, abandoned their previous position, and constructed a new approach. Thank you, Your Honor. His voice projected confidence he may not have felt. Upon further review, the government acknowledges the relevance of Westlake. A murmur ran through the courtroom. This admission alone was extraordinary. However, we maintain that the present case can be distinguished on several key grounds. He lifted a document handed to him by an assistant. First, in Westlake, the evidence was obtained through a single Section 1782 request, whereas here, multiple requests were filed in 3 different jurisdictions, creating what we might call redundant authority. He continued, outlining a complex argument about jurisdictional overlap, mutual recognition, legal bootstrapping across borders. His team had worked through the night, creating an intricate legal theory designed to bypass the Westlake restriction while appearing to respect it. The argument was creative, sophisticated, the kind law professors would dissect in seminars for years to come. Whether it was persuasive remained to be seen. Judge I. Hargrove listened attentively, occasionally making notes, his expression revealing nothing when Caldwell finally concluded. 30 minutes later, the courtroom waited breathless for the judge's response. Thank you, Mr. Caldwell, Hargrove said finally. A thorough analysis. Ms. Bondi, your response. Bondi rose smoothly. Thank you, Your Honor. Unlike Caldwell, she carried no notes, needed no documents handed to her. Mr. Caldwell has presented an impressive theoretical framework, one that might work if we were writing on a clean slate. But we're not, she paused, letting that sink in. The government's new position, while creative, fundamentally asks this court to create a distinction that doesn't exist in the statute. In Westlake, Your Honor, you wrote, and I quote directly, Section 1782 contains no provision for domestic use. No matter how the evidence is obtained, or how many jurisdictions are involved. Murmurs rippled through the courtroom. She had just revealed another passage from the Westlake opinion, one that directly contradicted Caldwell's entire new approach, and from the slight widening of Hargrove's eyes, it was clear he had forgotten. Writing those words, or never expected anyone to find them, buried in a footnote on page 42 of a 47-page opinion. Caldwell was on his feet immediately. Your Honor, that language appears in a footnote. It's clearly dicta, not essential to the holding. Hargrove's expression darkened slightly. I'm aware of where it appears in my opinion, Mr. Caldwell. The question is whether I meant what I wrote or was simply filling pages with irrelevant musings. The sarcasm was impossible to miss. Caldwell realized his mistake too late, had effectively accused the judge of including meaningless commentary in his rulings. Of course not, Your Honor, he backpedaled quickly. I simply meant— I know what you meant, Mr. Caldwell. Hargrove cut him off, turning back to Bondi. Please continue, Counselor. Bondi nodded. Your Honor, the government's new position essentially asks this court to create a loophole in a statute that Congress drafted with deliberate precision. It asks you to contradict your own clear statement in Westlake that Section 1782 evidence cannot be used domestically, regardless of how it was obtained. She paused again, perfectly timed. More troublingly, it asks you to ignore clear legislative history. She motioned to Thomas, who approached, handing her a slim volume. Congressional Record Volume 113, 1967. Senator Edward Long, the bill's sponsor, stated explicitly, This provision is intended solely for evidence gathering for foreign proceedings. It is not and never was intended as a backdoor method for domestic prosecution. The courtroom fell completely silent as the implication settled. She wasn't just arguing a technical legal point. She was suggesting that the government's entire approach violated congressional intent, used a statute for precisely the purpose its authors had explicitly prohibited. Judge Hargrove leaned forward slightly. Ms. Bondi, are you suggesting that the government has been misusing Section 1782 systematically and deliberately? The question hung in the air. Dangerous, potentially explosive. She could have softened. Her response could have provided the government a graceful exit. Instead, she met his gaze directly. Yes, Your Honor, that is precisely what I'm suggesting. Gasps from the gallery, government attorneys shifting uncomfortably. The record in this case shows that prosecutors were explicitly instructed to use Section 1782 requests, knowing the evidence would never be used abroad, but solely to circumvent domestic restrictions. She held up another document. This email from the lead prosecutor, obtained during discovery, states, use 1782 to get what we need. It's easier than domestic process. We can worry about admissibility later. The courtroom erupted in whispers. Caldwell's face had gone pale. The email had been missed in document review, or perhaps deliberately withheld. Either way, its existence was devastating to the government's position. Judge Hargrove's expression hardened. Mr. Caldwell, were you aware of this email? Caldwell stood, his composure shaken. Your Honor, I was not, but I would caution against reading too much into a single communication taken out of context. Hargrove stared at him for a long moment, the silence stretching uncomfortably. Ms. Bondi, he said finally, turning away from Caldwell, your argument is that Section 1782 evidence obtained as described in this email is inadmissible in this proceeding. Is that correct? Yes, Your Honor. And that without this evidence, the government's case cannot proceed. That's correct, Your Honor. The tainted evidence forms the core of their case. Without it, they have nothing but speculation. Hargrove leaned back. In his chair, fingers steepled before him, considering the implications. The legal community watching breathless as one of its most respected judges faced a pivotal decision, one that would affect not just this case, but potentially hundreds of others where similar tactics had been employed. Counselor, he said finally, leaning forward, his voice carrying that particular tone that silenced rooms, your argument fundamentally misunderstands the statute. The words hung in the air. Government attorneys exchanged relieved glances, thinking he was addressing Bondi, rejecting her position, returning to his usual deference to the prosecution. But he wasn't looking at Bondi. His gaze was fixed on Caldwell. Perhaps a first-year law student would make this mistake, but I expect better from someone with your experience. The room tensed at the thinly veiled insult. Bondi remained perfectly still, watching as Hargrove turned Caldwell's expectations. Completely upside down, can you cite a single case that supports your novel theory? Caldwell opened his mouth, closed it. No words came. The trap was set, the humiliation nearly complete, but directed at the government, not at Bondi, as everyone had expected. Bondi paused, hands resting lightly on the podium. The silence stretched, just long enough to command attention. Your Honor, she began, her voice steady, measured, I have the utmost respect for this court, but with all due respect, it is not my understanding that's flawed. She opened a leather portfolio and removed a single sheet. In your own ruling in Thompson v. Department of Justice 2017, you wrote, and I quote directly, she read his own words, contradicting his current position, words that perfectly supported her argument. You not only recognized this principle, Your Honor, you established it as binding precedent in this circuit. The courtroom fell completely silent, the judge's expression frozen somewhere between shock and disbelief. The aftermath of Judge Hargrove's ruling cascaded through the courtroom like a shockwave. Government attorneys sat stunned, some staring at their notes, others whispering urgently into cell phones, requesting guidance from superiors who would be equally shocked. The spectators in the gallery hardly dared breathe, witnesses to a legal earthquake whose aftershocks would be felt throughout the justice system. Caldwell stood rigid at the government's table, his face a mask of professional composure, betrayed only by the whiteness of his knuckles as he gripped the edge of the table. His career built on an unbroken string of victories in this very courtroom, before this very judge, now lay in pieces around him. Judge Hargrove gathered his papers, preparing to exit, having delivered one of the most significant rulings of his 3-decade career. "Court is adjourned," he announced, voice betraying nothing of what must be roiling beneath his judicial demeanor. But as he rose to leave, Caldwell spoke one final time. "Your Honor, the government moves for reconsideration." The request was desperate procedurally, unusual, a last-ditch effort to salvage something from the wreckage of their case. Hargrove paused, the room holding its collective breath. "On what grounds, Mr. Caldwell?" His tone suggested there were none that would suffice. "New evidence, Your Honor, that bears directly on the admissibility question." Bondi turned slightly, watching Caldwell carefully, sensing something unexpected, a final card being played. When all others had failed, what new evidence could possibly have materialized in the past 30 minutes, Mr. Caldwell? Hargrove's skepticism was evident, but he hadn't rejected the motion outright. Caldwell nodded to an assistant, who approached with a sealed envelope. "Permission to approach, Your Honor?" Hargrove nodded curtly. The assistant handed the envelope to the clerk, who passed it to the judge. As Hargrove opened it, Thomas leaned toward Bondi. "What is this?" he whispered. "I don't know," she replied, "but whatever it is, they're desperate." Hargrove removed several documents from the envelope, scanned them, his expression unreadable, then looked up, fixing Caldwell with a penetrating stare. "Where did you obtain these documents, Mr. Caldwell?" "They were delivered to our office this morning, Your Honor, from the State Department's legal division. They contained communication between Senator Long and the Justice Department at the time Section 1782 was being drafted. Communications that suggest a broader application than previously understood." Murmurs rippled through the courtroom. Bondi stood. "Your Honor, the government cannot introduce new evidence at this stage, particularly evidence they've apparently had access to but chose not to present until now." Hargrove held up his hand, silencing her. "I'm inclined to agree, Ms. Bondi. However, given the significance of this matter, I'll review these documents in camera before making a final determination." He turned to Caldwell. "This court does not appreciate last-minute surprises, Counselor. If these documents were available earlier, they should have been presented in the normal course." Caldwell nodded, accepting the rebuke. "Understood, Your Honor. We apologize for the timing." Hargrove gathered the documents. "We'll reconvene in 1 hour. I expect both parties to be prepared to address these new materials." The bang of his gavel punctuated the directive as he exited the courtroom, leaving uncertainty where moments before there had been resolution. The gallery erupted in conversation, legal observers debating what this meant for the case, for precedent, for Bondi's near victory. She remained at her table, outwardly calm, but inwardly recalculating. This unexpected development had changed the trajectory completely. "What do you think they found?" Thomas asked, gathering their materials. "Something significant," Bondi replied, "or they wouldn't risk angering Hargrove with a last-minute maneuver." "Can they actually overturn the ruling with this?" "Depends what's in those documents." She checked her watch. 1 hour isn't much time to prepare, but it's all we have. They exited the courtroom, finding a small conference room nearby where they could regroup, strategize, prepare for whatever revelation the government had produced. Across the hall, Caldwell and his team were doing the same, their earlier defeat replaced by cautious hope that their Hail Mary pass might yet be caught. 1 hour later, courtroom. 7B was again filled, the tension even greater than before, when Judge Hargrove entered. His expression was grave, thoughtful, suggesting the documents had indeed contained something significant. "Be seated," he commanded, the room complying instantly. "I've reviewed the materials submitted by the government," he began without preamble. They contained correspondence between Senator Long and then Attorney General Katzenbach discussing potential applications of Section 1782. He paused, looking up from his notes. In one letter dated March 17, 1967, Senator Long acknowledges that while the statute was primarily intended for foreign proceedings, it might, in limited circumstances, permit domestic use of obtained evidence. Murmurs filled the courtroom. Government attorneys exchanged hopeful glances, but Bondi remained still, watching Hargrove carefully, sensing there was more to come. "However," Hargrove continued, his tone shifting slightly. In a subsequent letter dated April 3, 1967, Senator Long clarifies this position, stating, "Any such domestic application must be expressly authorized by the court with full consideration of due process concerns, and only when no other avenue exists for obtaining the evidence in question." He looked up, meeting Caldwell's gaze directly. "The government has not satisfied these conditions. No express authorization was sought, no due process concerns were addressed, and alternative avenues existed but were bypassed for convenience." Caldwell's expression fell, realizing the documents had not provided the salvation he hoped, but reinforced Hargrove's earlier ruling, just with more nuanced reasoning. Furthermore, Hargrove continued, "These documents actually strengthen Ms. Bondi's position by confirming that domestic use was always viewed as exceptional, requiring specific safeguards that were not implemented in this case." He closed the folder containing the documents. "The ruling stands, Mr. Caldwell. The evidence remains inadmissible, and the government's motion for reconsideration is denied." The finality in his voice left no room for further challenge. Caldwell sat slowly, defeat written in every line of his body. The government's last. Hope extinguished, Thomas leaned toward Bondi. "We won," he whispered, twice. But Bondi's attention remained fixed on Hargrove, who seemed to have more to say. "Before we adjourn," the judge continued, "I want to address something of importance." The room fell silent again, sensing a significant moment. "This case has forced me to reconsider my own jurisprudence on Section 1782, to reconcile inconsistencies in my rulings, and to acknowledge where I may have strayed from the statute's clear language." The admission was extraordinary, unprecedented from a judge of Hargrove's stature. A jurist's first loyalty must be to the law, not to consistency, not to outcomes, and certainly not to either party's preferred position. He paused, his gaze sweeping the courtroom. Miss Bondi's argument today, while challenging to this court's recent practice, was firmly grounded in statutory text, legislative history, and, yes, this court's own precedent in Westlake. He nodded slightly. In her direction, it took considerable professional courage to advance that argument in this courtroom. Knowing my recent rulings on similar issues, that courage and Ms. Bondi's meticulous preparation led to a better, more faithful application of the law, which is ultimately what all of us here have sworn to uphold. As they walked toward the exit, a court clerk approached. "Miss Bondi, Judge Hargrove would like to see you in his chambers, if you have a moment." Bondi followed, uncertain what this final conversation would hold, but prepared as always for whatever might come next. Judge Hargrove cleared his throat, shuffled papers, a desperate attempt to regain footing lost in an instant. "That case is distinguishable," he attempted weakly. Bondi remained respectful, but unmoved. "I've prepared a detailed analysis of why it isn't." She handed documents to the clerk, pages comparing the cases point by point, meticulous research, irrefutable logic. The judge stared at the brief before him. The government, attorneys frantically whispering, searching for a counter-argument that didn't exist. Judge Hargrove's chambers stood in stark contrast to the formal austerity of his courtroom. Here, dark wood paneling lined the walls, floor-to-ceiling bookshelves overflowed with legal texts, some so old their spines had faded to illegibility. A massive desk dominated the center, stacked with case files, color-coded folders, the accumulated work of a lifetime in law. Photographs in simple frames adorned a credenza behind the desk. Family moments captured across decades. Hargrove in judicial robes at his swearing-in, younger with darker hair, standing proud next to a smiling wife, children at various ages, grandchildren in recent years, humanizing the man behind the bench. He stood now by the window, looking out over the Washington skyline, hands clasped behind his back, still in his judicial robe, though he had removed the white collar, a small concession to comfort. "Thank you for coming, Miss Bondi," he said, not turning around. "Please have a seat." She settled into one of the leather chairs facing his desk, waiting, respecting his pace, his process, whatever this conversation might be. He finally turned, regarded her thoughtfully. 30 years on the bench," he began, voice quieter than in court. "And very few attorneys have ever made me reconsider my position. Fewer still have prevailed using my own words." There was no anger. In his tone, only reflection, perhaps even appreciation. It was well done. He moved to his desk, sat heavily, age showing more in these private moments than it ever did in the public eye. "May I ask, when did you find Westlake?" 3 months ago, she replied honestly. "Buried in research for another case entirely." He nodded, unsurprised. "And you immediately saw the inconsistency with my subsequent rulings." "I did, Your Honor." Hargrove leaned back in his chair, studying her with new interest. "Most attorneys would have assumed I had a reason for the shift, that I had considered Westlake and deliberately moved in another direction. Did that possibility occur to you?" "Of course," she acknowledged, "but the statute's language is clear. Senator Long's intent was documented, and your reasoning in Westlake was sound. I couldn't reconcile that with your more recent decisions without concluding that something had been overlooked." Hargrove's expression remained neutral, but something in his eyes suggested her answer had satisfied him. "Overlooked," he repeated softly, almost to himself. "A diplomatic way of putting it." He opened a drawer, removed a folder, placed it carefully. On his desk. "You're familiar with stare decisis, I assume, the doctrine that courts should stand by precedent." "Of course, Your Honor, it's fundamental to our legal system. Stability, predictability, fairness." He nodded approval. "And yet, over time, even the most dedicated jurists can drift from their own established principles, not from malice or carelessness, but from comfort." He paused, carefully selecting his words. "When you've been on the bench as long as I have, certain patterns emerge, certain relationships with government counsel, certain expectations." He opened the folder, revealing the Westlake opinion, his own signature at the bottom. "I wrote this opinion, Ms. Bondi, every word of it, including that footnote, that decisive language about Section 1782. I believed it then, believed it completely, and yet somehow in Johnson, in Reed, in Blackwell, I ruled differently, not because I changed my mind, but because I stopped questioning, stopped examining each case with fresh eyes, began accepting arguments that aligned with what had become comfortable." The admission was extraordinary from a judge of his stature, his reputation. "Why are you telling me this?" Bondi asked carefully, her question direct but respectful. Hargrove closed the folder, regarded her with unexpected candor. "Because what happened in that courtroom today wasn't just about Section 1782 or admissibility of evidence. It was about the integrity of our legal system, about the responsibility judges have to apply the law faithfully, consistently, regardless of personal preference or institutional pressure. He stood, moved to the bookshelf, fingers tracing the spine of a well-worn volume. 30 years ago, when I took the bench, I swore an oath to administer justice without respect to persons, to faithfully and impartially discharge my duties. Somewhere along the way, I began to see myself as above scrutiny, began to believe that consistency with my recent rulings was more important than consistency with the law itself. He turned back to face her. You reminded me today that no judge is above correction, that intellectual honesty requires acknowledging error, even when inconvenient, especially when inconvenient. Bondi listened, absorbing his words, understanding their significance, their rarity. Your ruling today was correct, Your Honor, faithful to the statute, to precedent, to the principles of due process. Hargrove nodded. It was, but it shouldn't have required exceptional advocacy to get there. I should have seen it myself, remembered my own words, applied them consistently across cases. He returned to his desk, sat down again. I've asked the Chief Judge to reassign all pending Section 1782 cases to other judges in the circuit to avoid any appearance of bias going forward. Another extraordinary admission, a voluntary limitation of his own authority. That seems appropriate, Your Honor, though not strictly necessary. Your ruling today demonstrates your ability to apply the law correctly when properly briefed. Hargrove offered a small smile, the first she had ever seen from him. You're being diplomatic again, Miss Bondi. Properly briefed, he repeated, as though the failure was merely informational rather than a gradual ethical drift. He shook his head. No, I think some recalibration is in order, some time to examine other areas where I may have strayed from first principles. He reached for a pen, made a note. But that's not why I asked you here. He looked up, meeting her gaze directly. I wanted to thank you for having the courage to challenge me, to hold me to my own standards. It's what the system requires. Adversarial testing of ideas, principles, interpretations without fear or favor. Bondi nodded, accepting his words. I was just doing my job, Your Honor, advocating for my client within the bounds of the law. Perhaps, he acknowledged, but you did it exceptionally well, with integrity, preparation, and respect for the court, even while challenging its recent practice. He closed the Westlake folder. That kind of advocacy makes our system better, makes judges better. It's what I once was and hope to be again. He stood, signaling the conversation was ending. I expect we'll see each other in court again, Ms. Bondi. I look forward to it, Your Honor, she replied, rising as well, though perhaps with less drama next time. Another small smile from the judge. I wouldn't count on it, not with cases like yours, not with advocacy like yours. At the door he paused. One final thought. The law isn't just about rules, Ms. Bondi. It's about courage. The courage to speak truth to power, even when that power wears a robe, sits behind an elevated bench, has 30 years of experience. You showed that courage today. I won't forget it, nor will anyone else who was in that courtroom. She nodded, acknowledging his words, understanding their weight, their meaning, then departed, leaving him alone with his thoughts, his reflections, his renewed commitment to the oath he had taken 3 decades before. Downstairs in the courthouse lobby, Thomas waited, anxious, curious. What did he want? He asked immediately as she approached. To say thank you, she replied simply. For challenging him? Thomas asked incredulously. For reminding him of something he'd forgotten, Bondi explained, as they pushed through the heavy doors into the bright afternoon sunlight. Reporters swarmed immediately, microphones thrust forward, questions overlapping. Ms. Bondi, what happened in court today? Is this a landmark ruling? How did you find the Westlake precedent? What does this mean for other cases? She paused on the courthouse steps, considered her response carefully, mindful of the case's significance, of Hargrove's vulnerability, of the system they both served. Today the court applied the law as written, she said finally, ensured that evidence gathering respects due process, and demonstrated that our legal system works as designed when properly engaged. We should all be grateful for a judiciary willing to examine its own precedent and correct course when necessary. She declined further questions, moved through the crowd with quiet dignity, the same composure she had maintained throughout the extraordinary confrontation that had unfolded inside.